"Objection," the defense lawyer yells to me during the course of the doctor's deposition. I direct my client not to answer that question. What's all that about? Can I go ahead and ask the doctor a question, and now his lawyer turns around and says, "Doctor, you are not to answer that question"? Can he do that? You want to know what happened in a recent case where this exact thing happened? Come join me on a walk through the neighborhood as I tell you exactly whether he can or can't do that and what happened in this scenario. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. This is a medical malpractice case. During the course of this particular lawsuit, I had an opportunity to go ahead and question the doctor whom my client had sued. This is a process known, a pretrial process, known as a deposition, which is a question and answer session that's given under oath, and in pre-COVID times would take place in the doctor's attorney's office. During COVID times, it typically takes place on a Zoom video call. I am there, the doctor's attorney is there, the doctor is there, and a court stenographer is on the call to go ahead and record all of the questions that I ask and all of the answers that the doctor gives. The answers that the doctor gives represents his sworn testimony, and it carries the same exact weight as if he is testifying at the time of trial in court, in front of a judge, in front of a jury. So now, during the time that I'm questioning the doctor, I have an opportunity to ask him many different questions, not just about what he did and why. I get to ask him opinion questions and expert questions. And I also get to ask him what is the standard of care in this particular scenario. There are very few instances in these medical malpractice lawsuits in New York where an attorney can turn around ethically and properly and legally and tell his client not to answer the question. If the lawyer doesn't like my question, he can't turn around to the doctor and say, "Doctor, I don't like that question, don't answer it." There are very few instances where he is legally permitted to go ahead and do that. Now, I'm in the middle of questioning the doctor, and I ask him an opinion question, an opinion that calls for his expert medical knowledge. And his lawyer basically jumps out of his seat and says, "Objection! I direct my client not to answer. I direct you, Dr. Jones, not to answer that question." So now what do I do? What do I do in that instance where now I'm being blocked? I need the answer to this question. I need to know the answer. I need to know if the doctor knows the answer to this question. What can I do other than reaching across and shaking him and saying, "Doctor, you're going to answer my question," which you know I can't do. So instead, I have to do something else. I have to devise a different way to come up with a strategy that will allow me the opportunity to ask my question and to bypass the attorney's objection and to allow the doctor to answer my question. I'll tell you what I do. I'm going to rephrase my question. And now the attorney's going to object again. I'm going to rephrase it again. And I'll do it 5 times, 10 different times, 10 different ways. I'm going to do everything I can to get an answer to my question. For whatever reason, I need to know the answer to this question. And his attorney, in my opinion, is being obstructive. But I can't get into a whole pissing match with the opposing lawyer because that gets me nowhere. So what do I do instead? Instead of arguing with the defense lawyer about why he doesn't like my question or why he thinks it's inappropriate, I'm simply going to ask my question a different way. So I'm going to turn it around. "Doctor, do you have an opinion with a reasonable degree of medical certainty that a patient who comes into you complaining of a lump in her breast on the very first visit, good medical practice requires that you go ahead and take a detailed, thorough history? Would you agree with that?" He has to say yes. And his attorney can't bypass that. His attorney has to let him answer that question. Okay. "Doctor, would you agree that after taking a detailed, thorough history, good medical practice requires that you do a detailed, thorough physical examination? Isn't that correct? And part of your examination, especially in a patient who comes in with a complaint of a lump in her breast, is to do a breast exam. Isn't that correct?" Yes. "And part of a proper breast exam would include examining the patient while she's sitting up. Isn't that right?" Yes. "As well as while she's lying down. Isn't that true?" Yes. Okay, so now I'm going through a series of steps to establish what is the standard of care. And that's very important because I want to establish in the doctor's own words what is good medical practice, what is the standard of care for this particular scenario. So now I'm going to ask him hypothetical questions. Because in this scenario, the doctor does not believe that the patient came in making a complaint of a lump in her breast. There's nothing in his notes to confirm that, so he believes that she didn't make a complaint of a lump in her breast. However, my client said that was the only reason why she went to the doctor, because she had a lump in her breast. So, is it the doctor's poor record keeping, or did my client just not make that complaint? Well, that's something that I need to explore. Now, doctor, I want you to assume that Mrs. Jones came to your office complaining of a lump in her breast. Well, I don't believe that. That's not true. It's not in my records. Doctor, I understand that that is your position. I'm going to ask you from my question right now to assume that our version of the facts are true, that Mrs. Jones has testified in this case that she did complain on the very first visit that she had a lump in her breast. So for the moment, assume that to be true. In that instance, you would agree that good medical practice required that you go ahead and do a detailed history. Isn't that true? Again, he has to answer yes. And good medical practice in this instance, assuming these facts to be true, that good practice requires that you go ahead and do a detailed, thorough physical examination. Isn't that true? Yes. And you would agree that failing to take a detailed, thorough history in light of this patient's complaint would be a departure from the standard of care. Isn't that true? Objection. Doctor, you can answer over objection. Okay, so now I bypassed this objection. And doctor, you would agree that failing to do a detailed, thorough physical examination in light of this patient's complaint, that would be a departure from the standard of care. True? Objection. But doctor, go ahead and answer the question. Okay, so let's get back to the title of this video. The doctor is not being permitted to answer my question. And it's a question about an expert opinion. Doctor, do you have an opinion with a reasonable degree of medical certainty that if Mrs. Jones had a proper physical examination and a proper history taken, that her cancer would have been diagnosed earlier? Objection. Don't answer that question. And now the defense attorney and I are getting into a legal battle. I want the answer to that question. Doctor, I want you to assume that Mrs. Jones was diagnosed with breast cancer, advanced breast cancer, stage 3B, a year and a half later. Do you have an opinion with a reasonable degree of medical certainty that if an examination had been done on January 1st, when she says she came in complaining of a lump in her breast, whether her cancer would have been at stage 0 or stage 1? Objection. I direct the doctor not to answer that question. Now, how can I get around that? Well, you know what? I may not be able to, and I'll tell you why. This lawyer is trying to do everything possible to prevent his client from answering what's known as a causation question. A causation question connects the wrongdoing with the patient's injury. In these failure to diagnose cancer cases, one of the key issues that comes up in every single case is, well, if this had been recognized X number of months, years, or whatever earlier, would the patient's condition have been any different? Now, our expert at trial will come in and go ahead and give answers to those questions. I want this doctor, the patient's treating doctor, to give me an answer as to whether or not he believes my client, his patient's condition would have been any different had certain things been done. The defense lawyer doesn't want that information to come out through his own client's words. So he's going to do everything possible to prevent that from happening. And he may turn around, no matter how many times I ask the question, and say, I direct the doctor not to answer that question. That's improper. And now he's going to give some legal reason as to why he thinks my question is improper, and it would be unfair and inappropriate for the doctor to answer those questions. So what do I do in that instance? Well, I keep asking my questions. I'm going to try and get the doctor to answer. I'm going to raise those issues over and over again, and now we have a record. So after this deposition is finished, I now have the opportunity, when I get the transcript back, to go ahead and decide if I need to go ahead and ask the court to intervene and to show the judge that the doctor's attorney was obstructing this particular deposition and refused to allow the doctor to answer these questions. In that instance, the court may determine that, you know what, I'm right. And now he's got to bring the doctor back for another deposition to answer those specific questions. If I'm wrong, the judge is going to let me know that and say, no, I can't ask those questions for the following reasons, and now you move on to the next witness. So why do I share this information with you? I share it with you just to give you an insight and an understanding into what really goes on in these medical malpractice cases here in New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.